All right, Mr. Novak, if you're there, I need you to unmute your device. Okay, so we are on the record in file 24-51863-PP, Ashley Carpenter versus Montana Novak. This is a hearing on a personal protection order violation. Ms. Underwood, do you want to place your appearance on the record?
Ron Underwood for Mr. Novak this morning, Your Honor. Mr. Novak is in this connected matter in district court, Your Honor, which has a settlement conference of December 2nd, and I think a trial of December 12th. And we would ask that this matter be set after that.
Okay, so what I'll do is set this for December 18th at 8:15 a.m.
December what? I'm sorry, sir.
18th.
18th? Thank you, Your Honor.
Okay, so Mr. Novak, you next need to log in for this court on December 18 at 8:15 a.m. You'll use all the same Zoom information that you used to log in today. Sorry, if you were muted, I didn't hear what you said. Did you understand that, sir?
I understand. Thank you.
Okay, thanks. Then you can log out. And Ms. Underwood, do you need a breakout session with Mr. McCollum Rosa?
I would like one, please.
Okay, 1 second. Let me set that up.
Thank you, Your Honor.
Your Honor, I do need to speak with Mr. Fonseca just for a minute, I guess.
Okay, give me 1 second. Okay, Mr. Fonseca, I need you to unmute your device, please.
Okay.
I'm gonna put you in a breakout session with Mr. Glazier so you can speak to him privately.
Okay, thanks.
Judge, for Mr. Fonseca, I still need to set him up with 2 times a week drug testing, just so you're aware.
Okay, thank you. All right, Ms. DeMont, are you ready to proceed with Mr. Mulholland?
Yes, sir. I'll get him right now.
All right, this is file 23-21438-FC, People versus Michael Sean Mulholland. We are here today for a final pretrial in this case ahead of a trial date scheduled for October 22nd through 25th. We are proceeding today by video conference. Can I first have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
Katerina Dumont covering for Mr. Daly, for Mr. Mulholland.
All right, and are we ready to proceed to trial with this case?
Yes, Your Honor.
We are, Your Honor. It's my understanding we have made a plea offer to a plea of sexual conduct 2nd degree with 1 year in the county jail. It's my understanding the defendant is rejecting that offer, and I'm sure he's been informed by counsel that if he's convicted of the criminal sexual conduct first degree, the court has no choice but to sentence him to at least 25 years in prison on that count. So if they can just confirm that he's rejecting that offer on the record.
That's correct, Your Honor.
And Your Honor, we do have, we may not call Detective Greco. We have a stipulation, is my understanding, that we can, that we won't need him to establish that he found certain things at the residence of Mr. Mulholland and also photograph the residence. And I think how we would accomplish that is just through the testimony of Deputy Jones. So I'd ask the defense counsel to confirm that stipulation.
Yes, Your Honor, I talked to Mr. Daly with regards to that, and he is fine with that agreement.
And then also that Tara Kramer, she's from the DNA lab from the Michigan State Police Crime Lab, that she can testify via Zoom if we can't get her here in person. She's also scheduled to testify at a trial in Kalamazoo next week.
That's correct.
All right, have jury instructions and proposed voir dire been submitted?
They have, Your Honor.
Yes, Your Honor.
Oh, and just one final thing. We did a discovery demand at the very beginning of this case. I do have a witness list from the defense, but I do not have a report yet from their DNA expert regarding the substance of her testimony. So I'd ask that I get that report today or tomorrow at the latest, because I need to go over it with our DNA expert.
Yes, Your Honor, we reached out to her the past few days trying to get that report. So once we have it, we'll turn it over immediately.
But if I don't have it by the end of the day tomorrow, that's going to cause an issue with trial, and we may request an adjournment if we don't have that report by the end of the day tomorrow. Actually, because this has been rescheduled twice at the defense's request, I would ask that the court rule that defense has to turn that report over by the end of the day tomorrow, or be precluded from calling the expert witness. Because we've already adjourned this twice.
I don't know enough about the situation right now, having it, just been presented to me to make that kind of a ruling. So if the people want to make a motion, if you don't receive that by the end of the day tomorrow, I'll entertain that. But I'm not going to do anything now, because this was just.
Yeah, that's fine, Your Honor. I understand. Mr. Daly's office is always very cooperative with us, and I'm sure it's not through lack of diligence on their part, but we've adjourned the trial twice, and I just want to make sure that we have a chance to discuss that with our expert, because we filed our discovery demand back at the beginning of this case, which was over a year ago.
All right, are there any other issues we need to address today?
Not at this time.
Not on our end, Your Honor.
So we'll plan to begin trial on October 22nd at 9 a.m. unless the issue related to the expert witness needs to be addressed before then.
All right. Thank you, Your Honor.
Thank you.
Ms. Underwood, are you ready to proceed with Mr. McCollum Rosa?
Your Honor, I tried to track down his prosecutor yesterday. Who I know it was Mr. Bayonetto before. Can I ask who's handling that today?
I'm filling in for Mr. Bayonetto today.
Okay. Your Honor, I believe we want a short adjournment on this.
Okay, let me call the case. Let me call the case.
Oh, sorry.
This is file 24-21958-FH, People versus Skylar Austin McCollum Rosa. We're here today for a pretrial conference in this case and proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
E.B. McClure, on behalf of the people.
Rhonda Underwood on behalf of Mr. McCullough Rosa, Your Honor. I believe in this matter, we would like a short adjournment. However, I would like to be heard briefly on the issue of bond today, Your Honor.
How long of an adjournment do you want?
Just a couple weeks.
All right, so we'll go with November 6th at 8:15.
Thank you, Your Honor. And I will do this stip with Ms. McClure's permission.
Okay, what is you want to
As
address
to
regarding?
Mr. McCullough Rosa's bond, Your Honor. Mr. McCullough Rosa is charged with resisting and a domestic violence, Your Honor. Mr. McCullough Rosa has spent 55 days in jail, Your Honor, that have been very illuminating for him. He, I believe, has a case in district court and this case. But aside from that, I don't believe he has a record. He will be living with his mother. He is a source of financial support to his family. If he gets out, he will be able to go to work and provide that support. I would also propose that he be on a reporting system with Mr. Coast, and he will abide strictly by the no contact provision at this point, Your Honor. He understands there can be absolutely no contact. We would ask the court consider releasing Mr. McCullough Rosa on a PR bond with those stipulations, Your Honor.
Okay, Ms. McClure, anything you'd like to say?
Could I ask what the amount of bond is at this time?
It's $25,000 cash or sure.
Your Honor, based on the length that he's been in jail, I guess maybe a small cash bond reduction could be warranted just based on the charges. However, I think it's important to note, and I think the reason why he was given a little bit higher of a bond is because he did have a pending domestic violence with this same victim at the time that this occurred. So he was in violation of the no contact bond conditions. And then also upon being approached by the police officer after the altercation, and after the officer gave him a lawful command that he did run from that police officer and tried to get away. He, in addition, had a valid warrant out of Toledo Police Department. So I think the fact that he had a warrant as well as violated the no contact bond conditions does warrant some higher cash bond. But given that he's sat there and not been able to post, we'd be okay with a small reduction, maybe to like 10,000 cash or surety.
Your Honor, I think any cash bond is going to be a hardship, but anything the court can do. Thank you.
And his warrant out of Toledo was for an assault as well. I'm not aware of who the victim is in that assault.
All right, I would note that Mr. Coast did do an assessment on Mr. McCollum Rosa using the Ohio risk assessment system. He scored a 1 on that, which is a low score, indicating that he's likely to appear for hearings and not likely to be rearrested. There is a concern if this is apparently the second incident with the alleged victim in this case, and I think that along, well, I think that alone puts me in a position of needing to have some kind of bond in place on Mr. McCollum Rosa. Apparently, it was tried once and didn't work. So what I'll do is reduce the bond to $5,000 cash or surety with the requirement that he report as directed to Mr. Coast if he's able to post that.
Thank you, Your Honor.
I guess that can be cash surety or 10%, whichever.
Thank you.
All right, so I'm sorry, Ms. McClure, what was that?
Just was double checking what the next pretrial date was.
November 8th, 6th, November 6th.
Okay.
All right, Mr. McCollum Rosa, you can tell the officer that's with you that you are done with court for today.
All right. Thank you, Your Honor.
Okay, Mr. Glazier, I don't know what happened to Mr. Fonseca after you were in the breakout room, but he is no longer here.
Yeah, he's over at Dawn Farms and it froze up on me. And so I don't know if he's trying to get back on or not.
Okay.
And my laptop's battery died. That's why I zoomed out too. If he doesn't get on in a few minutes, you know, we probably can take care of this without him.
So I've got someone here by telephone. Let's put your phone number are 8073. Can you tell me your name?
This is Michael Santiago.
All right, 1 second, sir.
Okay.
Mr. Santiago, we'll put you back in the break or back in the waiting room until it's time for me to call your case.
Okay. I can't see you for some reason.
That's because you called in using your telephone. You didn't join using the Zoom app.
Oh, okay. 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 Gotcha. All right. I'll wait.
Right. Call for Joseph Allen. Who do we have here first?
Kelly and Judicial couldn't have Joseph. Thank you.
All right, I have someone logged in as David's iPad Pro. Can you tell me your name?
This could be, oh yeah, all right. This is a new, I don't know. I got a new operating system. It's Dave McCready. Sorry, I'll change my name.
All right, thank you. For the person that just joined the meeting and turned your camera on, I need you to unmute your device.
Can you hear us?
Okay. Yes, I can. Sir, what is your name?
Barry Ellison.
Okay. Mr. Ellison, your attorney, Mr. Murphy, is not logged into my courtroom right now, so I'm going to put you back in the waiting room until he gets here.
All right.
Okay, sir, you're Mr. Fonseca?
Yes,
Okay.
I was in the breakout room, but it froze up.
Okay. Do you still need to speak to Mr. Glazer?
No, I
Yeah.
think we can handle it from here, Your Honor. I got
Okay.
enough of a conversation in with him.
All right. So this is file 24-22002-FH, Matthew Lewis, People versus Matthew Lewis Fonseca. We are here today for an arraignment in this case. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure.
E.B. McClure, on behalf of the people.
John Glazier on behalf of Mr. Fonseca.
All right, and Mr. Glazer, does Mr. Fonseca wish to have the information read this morning?
No, Your Honor, we'd waive the reading of the information and plead not guilty at this time. We'd ask that this matter be set for a pretrial on December 5th, if possible. He entered a plea, I believe it was in this court, and has a sentencing on that date. And we need to work out a plea agreement regarding the new file, and I would indicate for the court that he is supposed to have some restitution by December 5th. He is in Dawn Farms. Matt, are the next phase you go into, are you going to be out and working?
No, I can't work for 90 days, so I gotta be in it for 90 days.
All right, so probably what I'd ask at the next date is if we could actually adjourn that sentencing and maybe enter a plea. He needs to get out and get a job and pay this off, but he's going into what's the next step you're going into? What's it called?
It's DFD, it's part of Don Farms.
Okay, and that's going to take 90 days, and you think you're going to go within the next day or two?
Yeah, I'm actually going tomorrow.
Okay, so he's not going to be able to pay the restitution that he was supposed to pay on the 5th anyway. He's going to need some additional time, I think, until he gets out of Dawn Farms.
All right, so I'll enter not guilty plea. We'll set it for a pretrial on December 5th at 8:15 so that it's coordinated with his other cases and we can deal with everything at one time.
Okay, November, December. You'll still be in, Matt, so you're gonna have to zoom in on the 5th from Dawn
Yeah, I
Farm.
know. Yeah, I
Okay?
got you. Yep, sounds good.
All right. All right, I think that's all.
Mr. Fonseca, do you know or have any idea when you're going to be released from Dawn Farms?
No, I don't. It could be over 90 days or 90 days or a little bit more, a little bit less. Depends on what goes on in the next couple months.
Okay, so you have bond conditions on this case that require drug testing, and so you're gonna need to get that set up with Mr. Coast as soon as you're released.
Okay.
So one of the first things you need to do after you're released is contact Mr. Coast here at the Lenawee County Circuit Court.
Okay. You're talking about in the future?
Arthur, I'm located up on the 3rd floor, so you just come up to the 3rd floor and go over to the clerk's office and it'll alert me. That's if you're released from treatment.
Okay, got you. I got you.
Thank you.
But if you're still there on December 5th, remember to zoom in.
Yeah, I will.
Okay.
All right. So you are all set for today then, Mr. Fonseca. You can go ahead and log out.
All right, you guys have a good day. Bye.
All right. Thank you, Your Honor.
Okay, Mr. Moan, I do have Mr. Sherwood here.
Thank you, Judge.
You need a breakout session with Mr. Sherwood?
No, I think we're ready to go, Ms. McClure. I think, and I talked probably just a little bit more time, Judge.
I'm here to address bond conditions with Mr. Muad.
Okay.
Half of Mr. Sherwood.
Oh, hi, Leigh.
Hello. I'm his
All right,
attorney in the abuse and neglect case for lawyer guardian ad litem.
Yeah, very familiar. Thank you for coming on. Thank you.
All right, Mr. Sherwood, are you there?
Yes, sir.
Okay, this is file 24-21855-FH, People versus Charles Thomas Sherwood. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people.
Elias Muad appearing on behalf of Mr. Sherwood.
I'm Lee Jamison Heiss. I am on behalf of Mr. Sherwood today too.
All right, so where do we stand with Mr. Sherwood's case today?
Ms. McClure did receive. Oh, go ahead, Phoebe. Go ahead, Phoebe. I'm sorry. So sorry.
As it relates to the underlying pretrial judge or the underlying criminal charge, I did receive some information from Mr. Muad that I've, excuse me, reviewed that may change what the resolution or the offer is in the case as it stands. I just need a little bit more time to flush that out with Mr. Muad and try and figure out what we can do on this. So this time we're asking for a short pretrial adjournment, maybe 3 weeks or 4 weeks at the most. And then I've also been from probate court given a heads up as to what they're recommending as far as I guess parenting time, we'll call it, with the parents, and assuming Ms. Heiss can explain that. I don't believe I have an objection to it. I would like that his bond conditions mirror what the probate court orders are, but I want to make sure it's what I was informed of.
Okay. So Mr. Muad, do you have any objection to an adjournment, say to November 6th?
No, Judge, that's fine. And that's what I contemplated along with my client. He understands.
No. Okay. No. So we will adjourn that to November 6th at 8:15. And
just not to interrupt, but Mr. Sherwood is shaking his head no. I don't know, is that date not good or?
Mr. Sherwood, what's What's the matter?
Just being postponed. That's my problem here.
Mr. Sherwood,
This
Mr.
has
Sherwood,
been-
Lee, hang on. Don't say anything. Lee and I will talk to you. I think we have a plan here. Is it okay on the 6th? Are you available on the 6th?
Yeah.
Okay,
Yep.
that's it. Thank you. Thank you.
Okay.
All right.
All right, so let's go ahead and address the bond issue then.
Your Honor, Lee Jamison Heiss, I am the lawyer guardian ad litem for the minor children in this case, one of whom is the alleged victim. In the abuse and neglect case, that's file 24-000074NA. As recently as October 7th, Mr. Sherwood was found to be making progress. He has accepted responsibility for jurisdiction. The children are placed with their mothers, and there has been no contact with the children to this point. On October 7th, Judge Sala did order supervised visits if this bond condition were to be modified, so that if you would allow your case to mirror our case, he would have to participate in a trauma assessment with the children and some therapy, but also supervised visits would be allowed. At this time, I have met with the children face to face, and I do believe that is in their best interest.
No objection, obviously, Judge, on my part.
Okay, Ms. McClure.
Just to clarify, is that with Colton as well, or just the other children?
It's with all three.
How would that look with Colton?
So the judge has ordered, let's see, the exact language in the order. He's to cooperate with a trauma assessment, so he will see those children at the trauma assessment, and the visits with Colton are therapeutic supervised. So they will be supervised by an actual therapist, not a family member or something like that at this time.
And where is Colton living at this time?
He is placed with his mother, living with it, but technically living with his maternal grandfather in Napoleon, Michigan.
Okay. And when this was brought up in district court, Mr. Sherwood was represented to me that he had no interest in seeing Colton again. Has that changed?
You know, I don't know that side of it. I can only say that Colton's needs and interests, when taken as a whole, his school history, his home history, his personal feelings, he would like to have this therapeutic supervised visits with his father. I don't know that his father will participate. I don't have his confidence to have inquired.
Okay. Judge, at this time, I have no objection to the bond conditions in this case being modified to mirror the probate court order, the current probate court orders, and any future orders that may come down, however that looks.
Okay. All right, so the court will then modify the bond conditions. I guess, is it sufficient that I just say that they must comply with the probate court's orders in the abuse and neglect case?
Yeah, and maybe
rather than try to explicitly state them in this record.
Yes.
Yeah, and if you want to clarify in your order that pertains to contact with Mr. Sherwood and any minor children, I think that would be sufficient.
Okay, so I'm sorry, is that agreeable, Ms. Heiss and Mr. Mawat?
Yes.
Yes, Judge.
Okay. All right, so I will modify the bond conditions in that way. Let's see, Ms. McClure, would you do a stipulation in order for the adjournment?
Yes, I can do that. That was November 6th.
Correct.
Correct.
Okay.
All right, are there any other issues we need to address with the case today?
Thank you, Ms. Jamison. Thank you, Ms. McClure, and Judge Charles, or Mr. Sherwood, I will call you later on, okay?
And
All right.
nothing on behalf of the people. Thank you.
All right.
I do want to ask, does that change the tether coming off, or does that stay on? How does that work?
Well, I can ask Ms. McClure how she feels about the tether. Do you still need it on, Ms. McClure, or what do you think?
If there've been no violations, I would leave it in the discretion of the court.
And I'm not aware of any violations. I think Mr. Coast may still be on there, but I'm not aware of any.
Ms. Heist, do you have any input on that issue?
He is doing his case service plan, and so on our account, he is in compliance with his terms of the abuse and neglect case, if that helps.
Okay, Mr. Coast, any input on the tether issue? I don't know if you said anything, Mr. Coast, but your device was muted. Did you have any input on the tether issue?
Judge, he has been on GPS tether. He has done a good job with that. I received no violations to date.
All right. So at this time, then I'll also eliminate the requirement of the GPS tether.
Charles, I'm going to go ahead and get a hold of JSG. You can return your device at this time then.
Okay, thank you.
All right. If there's nothing else, then everyone can log out.
Okay. Mr. Sherwood, you can go and wherever you put it on, you can go back and they'll take it off. Okay.
Yep, thank you, sir.
All right. All right, Ms. Heist, thank you. Oh, she's off. All right, bye, everybody.
Did you call them? Oh, you said. Okay, Mr. Malero, I have Mr. Madrid here in the courtroom. Are you going to need to speak with him?
No, Your Honor.
Mr. Madrid, you want to come forward to the podium, please? Okay, this is file 24-21882-FH, People versus Luis G. Madrid. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, let me have the attorneys place their appearances on the record. Who do we have for the people on this one?
Sorry, Judge, I thought Ms. Wagner was logged on. I can appear for the people.
Okay, so we have Ms. McClure and Mr. Malero, you want to place your appearance on the record?
Salvatore Malero on behalf of Louis Madrid.
Okay, where do we stand today, Mr. Malero, with Mr. Madrid's case?
Your Honor, the matter is close to resolution, but not quite there. I'd ask to adjourn it one more time.
Ms. McClure, anything we need to add from the people's side?
No, Judge.
I will adjourn it then to November 13th at 8:15. That's going to be the last adjournment in this one. We're 91 days since bind over, so it will be set for trial at the next pretrial if it's not resolved at that time.
Thank you, Judge.
Mr. Malero, would you do that stipulation in order, please?
Yes, I would do that.
Okay, so Mr. Madrid, your next date will be November 13th at 8:15 a.m.
All right, thank you.
Okay, thank you. Okay, and Mr. Malero, I also have Ms. Bokor here in the courtroom. Do you need to speak to her?
Yes, I do.
All right, Ms. Bokor, if you'll step outside to the hallway, there's an iPad out there. We'll get that set up so that you can speak to Mr. Malero. So Valerie particularly had an issue with it, they just.
Hello?
All right, yeah, what, can you tell me your name, sir?
Yes, my name is Stephen Johnson.
Okay. All right, Ms. Underwood, you need to speak to Mr. Johnson?
Just very briefly, Your Honor.
Okay. Mr. Johnson, I'm going to put you in a breakout session with Ms. Underwood.
Okay.
Okay, Ms. Bokor, I'll put you in a breakout session with Mr. Malero right now.
Okay, thank you.
Thank you, Judge.
I don't know. There she said.
Ms. Frank, is Tamaris?
Up to the restroom.
What's that? You're
She went to the
okay.
restroom.
All right, we'll wait till she gets back.
Okay.
Or is Ms. Hennigan your attorney, Ms. Frank?
Yes.
Okay. As soon as she gets here, we'll proceed with your case. All right, Ms. Underwood, are you ready to proceed with Mr. Johnson?
Yes, Your Honor, I am.
All right, so this is file 24-21757-FH, People versus Stephen Jermaine Johnson. We are here today for a pretrial conference. In this case, we're proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood, Your Honor, for Mr. Johnson this morning.
Okay, and where do we stand with Mr. Johnson's case?
Your Honor, Mr. Johnson did make a payment yesterday at the front of the court office of $150. He will provide proof of that to me today, and I will forward that to Ms. Brenner. Your Honor, I think what we need and what I'm hoping Ms. Brenner will agree to is a very short adjournment, perhaps November 6th. And at that time, we should be able to resolve this matter, Your Honor. Mr. Johnson has a couple of job interviews, and I'm hoping we can resolve that at this point.
Okay, Ms. Brenner.
Your Honor, I had informed counsel at the last date that I wasn't going to agree to an additional adjournment unless there were payment efforts. He made a payment at such the last second that I can't confirm that a payment was made. His current obligation is 275, so 150 isn't near what he needs to pay to keep current. Since he posted his bond in March, his arrears have not climbed to where we started off. So we're going backwards instead of forward. I'm going to reluctantly agree to Miss Underwood's request for a short adjournment, but I want to stress to the defendant and to the court that I'm not pleased with the progress in this case, and I will not be agreeing to further adjournments. He either has a plan in place and he's making payments, or he's pleading and we're proceeding to trial at the next date. I'm not pleased.
All right, so what I'm gonna do is adjourn this to November 6th at 8:15.
And I will be
And is
happy
that-
to do the stiffen adjournment with Ms. Brunner's permission.
Thank you.
At that time, if there's not resolution or progress in the matter, we'll be setting it for trial.
Thank you.
I'm also going to enter an order for fingerprints. We don't have fingerprint information in the file. So I'm going to do an order for prints. Mr. Johnson, you're going to need to get in touch with the Michigan State Police to get your fingerprints taken.
Do I call the courthouse to get the information to call them, or?
There should be, I think there's information in the order. If there isn't information or you have further questions, you can contact your attorney.
Okay.
All right, so you're all set. You can log out for today.
Thank you, Your Honor.
Thank you. Mr. Malero, are you ready to proceed with Ms. Bocor?
Yes, Judge.
Ms. Bocor, do you want to step forward to the podium, please? This is file 24-21970-FH, People versus Heather Marie Bocor. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, I have the attorneys place their appearance on the record, beginning with who do we have for the people on this one? We have a prosecutor for Ms. Bocor.
Anyone? Anyone?
All right, well, I guess we'll proceed when we have a prosecutor available to us.
Judge, we'd waive the prosecutor's presence.
Appreciate that, Mr. Malero. Yeah, I guess Ms. Bocor, you can go back and sit down if you wish. Mr. McCready, are you there?
I am here, Your Honor. I wasn't paying attention to the defendant's name.
Yeah, so we have Ms. Bocor we're looking for a prosecutor on, or just let me know what cases you're here to handle.
I'm on Joseph Ballard.
All right, we have called for him at the jail. No. I have a Lenawee jail Zoom device that has its camera off and microphone muted if there's someone there. Okay. Are you Mr. Ballard?
Yes. Yes.
Okay, yeah, sorry. We have, apparently your attorney, Mr. Glazier, has logged out. So just hold tight for a minute there. He's back. Oh, there he is. I'm sorry. Mr. Glazer, do you need to speak to Mr. Ballard?
Yes, Your Honor.
All right, Mr. Ballard, I'm gonna put you in a breakout session with Mr. Glazer if you give me just about 10 seconds. Okay, Ms. McClure, can you handle Heather Bocor's case?
Yes, I can. Sorry, Judge, I thought you had Mr. McCready's case up next, so I stepped out for a minute.
Okay, all right, Ms. Bocor, you want to come back up? Okay, this is file 24-21970-FH People versus Heather Marie Bocor. We are here today for a pretrial. Can I have the attorneys place their appearances on the record?
B.B. McClure, Map the People.
Salvatore Malero on behalf of Heather Bocor.
All right, and Mr. Malero, where do we stand with Ms. Bocor's case today?
Judge, I'm going to ask to adjourn this one time, although it's not related. There's a misdemeanor case that we're trying to get a total resolution on all files. So that is the reason I'm asking for the adjournment.
All right, Ms. McClure, anything from the people's side?
Nothing to add, Judge.
All right, let's go with November 13th at 8:15 a.m.
Thank you, Judge.
And Mr. Malero, would you do that stip in order?
Yes, I will do that.
Okay. So Ms. Bocor, your next court date is November 13th at 8:15.
Thank you.
Okay, thanks. Okay, Mr. Glazer, you ready to proceed with Mr. Ballard?
Yes, I am, Your
Honor. This is file 24-21953-FH People versus Joseph Wallace Ballard. Here today for a pretrial conference in the case, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Mr. McCready.
Good morning, Your Honor. Dave McCready for the people.
John Glazer on behalf of Mr. Ballard.
And Mr. Glazer, where do we stand with Mr. Ballard's case today?
Your Honor, my client's going to enter a plea of guilty to count 3, which is a CCW concerning carrying a concealed weapon. And he's also going to plead to guilty to count 5, which is resisting and opposing, with the understanding that the other charges, I don't know if there's a supplemental on this or not. If there is a supplemental, that would be dismissed along with the remaining charges. There would be a killabrew that the sentence would be 1 year in jail, but 6 months of that would be suspended.
All right, Mr. McCready, is that a complete and accurate statement of the plea agreement?
Yes, it is, Your Honor.
Mr. Ballard, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do.
You are Joseph Wallace Ballard? You answered, I was not able to hear it. Mr. Ballard, can you hear me?
Yes.
You are Joseph Wallace Ballard?
Yes, Your Honor.
Mr. Ballard, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 3, carrying a concealed weapon?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison or a $2,500 fine?
Yes, Your Honor.
Is it also your intention to plead guilty today to count 5, assaulting, resisting, obstructing a police officer?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine?
Yes, Your Honor.
Are you satisfied with Mr. Glazer and the advice that he's given you?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. McCready?
It is.
That's correct, Your Honor.
Is that also your understanding, Mr. Ballard?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you were guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Ballard, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization.
Yes,
Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about August 2nd, 2024 in Rollin Township, Lenawee County, Michigan, that you did commit the offense of carrying a concealed weapon?
Guilty.
And how do you wish to plead to the charge that on or about August 2nd, 2024 in Rollin Township, Lenawee County, Michigan, that you did commit the offense of assaulting, resisting, or obstructing a police officer?
Guilty.
Has anyone made any threats to you to induce you to plead guilty to those charges?
No, Your Honor. It was my choice.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargaining to induce Mr. Ballard to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Ballard, other than as we've discussed on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
He said 1 year, 6 months suspended.
Okay, so just what we've talked about here today.
Yes, this is what we talked about here today.
Okay. Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Glazer, would you like to cover the factual basis?
Yeah, Mr. Ballard, you understand that the plea you're entering here today, if the judge at sentencing follows through with that you're gonna serve 6 months in jail, but 6 months will be suspended. Do you understand that?
Yes.
Do you also understand, though, that if you do something either to violate your probation or upset the judge in some way, that he can give you that other 6 months in jail? Do you understand that?
Yes, I do.
Do you also understand that if you do something serious enough to violate your probation, that he could sentence you to prison for up to 5 years on the CCW? You understand that?
Yes, I do. I'm aware.
All right, so you gotta follow your probation and do what you're supposed to be doing, or you could get significantly more time. You understand that?
Yes, sir.
All right. On August 2nd of this year, you were here in the city of Adrian County, Lenawee. Is that correct?
Ms. Rowland.
Roland.
I said you were here on August 2nd of this year. You were here in Lenawee County in the state of Michigan. Is that true?
Oh, yes, yes.
And you were, I think, if I remember right, you were in a car that was at a gas station or something of that sort. Is that correct?
Yeah, I was sleeping at a gas pump.
All right. And at that time, you had in that car, you had a pistol of some sort. Is that correct?
Yes.
All right. And when the police came, they were called because you were sleeping there. You took off in the vehicle. Is that right?
Yep.
And you did resist and oppose the police officer's attempt to arrest you or to question you about this incident. Is that true?
Yes.
All right. I don't have any other questions, Your Honor.
People are satisfied.
All right, has the court complied with MCR 6.302 B, C, and D, Mr. McCready?
Yes.
Mr. Glazier?
Yes, it has, Your Honor.
All right, I will accept the plea that's been given understandably, voluntarily, and accurately. Mr. Ballard has had full knowledge of his rights. He's had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed on the record here today. I will refer this matter to the probation department for a pre-sentence investigation, and we can set sentencing for December 5th at 8:15 a.m. Mr. Ballard, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Yes, sir. Yes, Your Honor.
Okay, so you can let the officer with you know that you're done with court for today.
Okay, thank you.
Thank you, Your Honor. I think that's all I have with you this morning.
Okay, thank you, Mr. Glazier. You call for Teresa.
Yes, sir. Yeah.
Mr. Milaro, Mr. Santiago is here. Do you need a breakout session with him?
Yeah.
No, I do not, Judge.
All right, Mr. Santiago, are you there?
Could we have Teresa Ward? All right, thank you.
Mr. Santiago, are you there? Mr. Santiago, can you hear me? Okay, we'll pass Mr. Santiago. I don't know if he's walked away from his phone or what's going on, but we'll pass him for now. We can do Ms. Hennig ready on Ms. Frank's case.
I am, Your Honor.
Okay.
I think we need this, we need Phoebe Meyer. I'm right here. Hi, Phoebe. Good morning. Hey.
Yeah, well.
All right, hang on, Mr. Santiago. I've got to do another case first. I'll get to yours next.
Okay, okay.
This is file 3-21418-FH People versus Carly Lynn Frank. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. I would also note that the court has recently received a finding order on competency, or a finding on competency from the Center for Forensic Psychiatry. First, we have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, on behalf of the people.
Good morning, Your Honor. Tamara Hennigan on behalf of Ms. Frank. Ms. Frank is to my left.
Okay. And so as indicated, the court did receive a report from the Center for Forensic Psychiatry. Are you prepared at this point to do a hearing on that, or is there more that we need to do there?
Your Honor, we are prepared to go forward. However, it's clear from the report that Ms. Frank has been found competent. And this was more of a proactive act in asking for the competency evaluation because she had had a head injury. So we don't have any further argument at this time on the matter. We would stipulate to the entry of the report.
Okay, Ms. McClure, do the people stipulate to entry of the Center for Forensic Psychiatry report?
We do, Your Honor.
Okay. Is there any other evidence or argument that the people want to make?
No, Your Honor.
I'm sorry.
Okay, and any other evidence or argument that the defense wishes to make?
No, Your Honor.
All right, I have received the report from the Center for Forensic Psychiatry dated October 8, 2024, written by Jessica Pawlinski, MD. It does have a fairly thorough recitation of the evaluation that took place, with the ultimate finding being that Ms. Frank is competent to stand trial. That is the only evidence at this point before the court on that issue. And so I am going to find that Ms. Frank is competent to stand trial. The case shall continue to the next stage of the process. You have an order to that effect that I'm signing. Okay, so having said that, where do we stand with Ms. Frank's case today, Ms. Hennigan?
Your Honor, if we could get a date for jury trial and move forward as quickly as possible. I know that it is approaching the end of the year and the court's docket is probably very busy. However, I will only be available to work with Ms. Frank until the end of this year, and so I'm hoping to help her get this resolved. If not, then if it goes into next year, I'll obviously work with whoever she's assigned from the PD's office to get her through that.
Okay, and how much time, how many days of the trial do we need for this?
I'm gonna defer to Ms. McClure. She's had multiple co-defendants in this and she would have a better idea.
Yeah, I think there's quite a few witnesses as well as exhibits, and that was kind of part of the issue with trying to find a trial date. I think I could maybe get it done in 4 days. I don't have a witness list or an exhibit list from defense, so I think just my part of this could take up to 4 days. And that's also part of the trouble in setting a quick trial is I need to have time to be able to subpoena all these individuals, and some are in jail, and it's gonna take some time.
And my client has informed me of a couple of witnesses today that she wants me to provide to Ms. McClure and some additional information that will likely be exhibits. So I would say that we will probably need a day, at least 1 day for for the defense.
All right, so we'd be looking at 5 days. Okay, so Ms. Clark, could you find us a 5-day jury trial date? Is that going to be possible before the end of the year?
You could do December 10th and it'd be backed up to already 2 jury trials. December 10th, December 11th, 12th, the 13th, and December 17th.
All of that works for me, Your Honor.
It's kind of tight for me. I am scheduled to go out of town on the 17th, and it's a pre-planned vacation that I'm gone for then 2 weeks. So it would just be tight for me in case we don't get done.
Okay. If that's the case, then it looks like it's gonna go into next year. And so it wouldn't seem to me to make sense to try to schedule a date if Ms. Hennigan is gonna have to withdraw from the case and have an attorney assigned, so.
We could possibly do it December 3rd, the 4th, 5th, 6th, and then December 10th. There'll be backed up to Jason Lindsay's jury trial, and then a Nathan Edwards jury trial and Lucas Tucker.
I'm available those dates as well, Your Honor.
The only day
If we choose-
I'm sorry, the only day I'm unavailable is the 6th, but I could move some stuff around if we need to do that.
I was also gonna say that, what I can do in the meantime is, contact the PD's office and let them know that if that does not go forward, that obviously the trial date would be moved, so I can ask them to be prepared, to have someone work with me so that they would be brought up to speed, for the next trial date if it gets moved.
I would rather have a firm trial date just because there are so many witnesses.
Understood. Do you want to set it for another pre-trial, Your Honor, and I can get in contact with the PD's office so that we could have another pre-trial in the next week or two, and they could have another person here, and then I can start to pass everything along to them so they can prepare
All right,
a trial in their schedule.
let's set it for November 6th for a pre-trial. And we will see if we can get that transition to happen at that time and then be able to.
And it does have to be a special appointment because they've represented individuals who are testifying against Miss Frank.
Right. Okay, Ms. Hennigan, could you do that stipulation in order for adjournment, please?
Yes, Your Honor.
Right. Is there anything else we need to address with this case?
No, thank you, Your Honor.
Nothing on behalf of people.
Okay, thank you. Mr. Fry, do you need to speak with Ms. Ward?
If I could, that would be helpful, Your Honor.
Okay, 1 second. Okay, Mr. Santiago, are you there?
Yes, I am.
All right, and Mr. Malero?
Yes, I'm here, Judge.
Okay, this is file 24-21935-FH, People versus Michael Ramon Santiago Sr. We are here today for a pretrial conference in this case, also a hearing on a contempt of court for violating bond conditions. We are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure, the people.
Salvatore Malero on behalf of Michael Santiago.
All right, I'm sorry, Mr. Santiago, I need you to, I don't know what's going on, but we're getting background noise, like you're shuffling things around. You need to stop that because it's interfering with our ability to hear.
Yeah, I'm not shuffling nothing. I'm
There's something creating noise coming from your device that needs to stop.
Yeah. Maybe, let's see. No, there's nothing on it at all, sir.
Mr. Malero, can you try placing your appearance on the record again?
Salvatore Malero on behalf of Michael Santiago.
All right, and where do we stand with Mr. Santiago's case today?
Your Honor, we are still trying to secure an expert witness in this matter with respect to the breathalyzer that occurred during the stop. So I'd ask to adjourn this at least one time so we could finalize that. And then I think we'll be in a position to go forward, either resolve it or set for trial.
All right, I will adjourn it to November 27th at 8:15. Mr. Malero, can you do that stip in order?
Yes, Your Honor, I can do that.
We also have a pending warrant for Mr. Santiago based on an allegation that he again blew positive numbers at the sheriff's kiosk. So Mr. Santiago needs to turn himself in on that warrant.
Your Honor, I've been in
Is this
there.
another, Judge? Is this an additional contempt or is this the contempt you were referring to?
This is a new one, right, Mr. Coast?
It is, Judge. He registered a 156 back on 9/19. He did turn himself in on that warrant. He is warned not to blow numbers again. A week later on 9/27 at 10:01 p.m., he registered a .029 at the kiosk. So thus the second warrant was issued.
So the second warrant is related to the 9/27/24.
That's what the machine. Yeah.
All right. Thank you, Judge. And Mr. Coast.
So, yeah.
Mr. Santiago, you gotta turn yourself in.
Okay. I didn't even know I blew dirty. I don't see how. I haven't been drinking.
Well, okay, we'll deal with it, but you gotta turn yourself in on the warrant.
Yes.
Okay.
Yes.
Hey, Sam,
yes, I understand that.
Sam, I'll send
This
you
is
over a copy of
crazy.
this warrant too.
Okay, thank you.
All right, I'll be in there today.
All right. You can hang up then, Mr. Santiago.
Okay, I'll be in there in a little bit. That's crazy.
We have any- Could you see Jill has a second room for us? Could you call for? You need to speak with Ms. Justice. Yeah, okay. We can call for her now with Ms. Justice.
Do you have a second Zoom room for us? Do you have a second Zoom room you could use for us? No, we need Jenny Justice, please. Yes. All right, thank you. Bye.
Mr. Goldstein, are you there?
Yes, Your Honor.
Yeah, so Mr. Simmons, when I looked him up yesterday in the computer system, it looks like he has a probable cause conference on the underlying charge next week. Is that right?
Your Honor, he does. Mr. Hartung and I have worked out an agreement. We're going to be asking Judge Shadler to take the waiver today because Judge Morgan is out of town, right, or not available. So we were going to be asking if we could set this over until the 30th. We'll have both files in front of you on the 30th. We have a resolution on both files.
And do you need to do anything with him on the record today?
No, Your Honor, he's aware of the situation.
So October 30th. Okay. If you would want to just do a stip in order and send that in, we can handle it that way then.
I will do that. Thank you, Judge.
Yep, sorry, I would have addressed it earlier. I get lost with when people turn their cameras off. I forgot you were there.
Not a problem. Not a problem at all.
Okay, have a nice day then.
Thank you.
Okay, I have a jail 8 device that has its camera off and microphone muted. If there's someone in that booth, you need to turn the camera on and unmute the device. Okay, and you are Ms. Justice?
Yes.
Okay, I'm going to put you in a breakout session with your attorney so that you can speak to him privately.
And Judge, I have to go up to Judge Anzalone to handle a case in person, and I was gonna have Mr. McCready finish up what you had left on the docket. But I know we have Mr. Malaro here, and I was wondering if we could address Mr. Stevens' case off the record. And we may not need to get him or call him from the jail.
Okay, Mr. Malero, are you comfortable doing that?
Yeah.
Judge, I'm sorry, I'm on the phone with Mr. Santiago right now. I didn't hear what you were talking about.
All right, I'll do you have a minute to wait?
Yeah, I have a minute. Yep.
Okay.
All right, thank you.
Let me call Ms. Ward's case real quick while we're waiting on that. So this is file 23-21923-FH People versus Teresa Lynn Ward. We're here today for hearing on a contempt of court as well as a pretrial on the underlying charges. We are proceeding today by a video conference. First, let me have the attorneys place their appearance on the record, beginning with Mr. McCready.
Dave McCready for People.
Brian Fry, attorney for Teresa Ward.
And Ms. Ward's here by Zoom from the jail. Mr. Fry, where do we stand with Ms. Ward's case today?
Yeah, a couple things, Your Honor. I don't think we're here on a pretrial underlying charge. She was sentenced on that last week. But this was a bond violation for before sentencing. She had tested positive, I think, for cocaine and had missed a drug screen. So I think we're here on those contempts.
I apologize. You are correct.
Okay. So, yep, go ahead.
Yep, no, go ahead.
So, Your Honor, I have spoken to Ms. Ward, about those contempts, and it's my understanding that she would admit to testing positive as well as for missing the drug screens at this time.
All right, Ms. Ward, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury.
Yes, I do.
And you are Teresa Lynn Ward, correct?
Yes, I am.
Ms. Ward, you've had an opportunity to discuss the matter with Mr. Fry, is that correct?
Yes, I am.
Are you satisfied with Mr. Fry and the advice that he's given?
Yes, I am.
You understand the maximum possible penalty for contempt of court is up to 93 days in jail or up to $7,500 in fines.
Yes, I do.
Do you understand you have a right to contest the contempt court charge and have a trial?
Yes, I do.
Do you understand that you, throughout that trial, you'd be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, I am.
You understand you have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you have the right to have the court order any witnesses you have for your defense to appear at your trial.
Yes, I am.
Do you understand that you don't have to testify at your trial if you don't want to, and no one can say anything about you not testifying or hold that against you in any way?
Yes, I am.
You also understand that you have the right to testify at the trial if you wanted to testify.
Yes, I am.
And how do you plead to the charge that you committed contempt of court by testing positive for cocaine from a drug screen collected on September 17, 2024?
Guilty.
And how do you plead to the charge that you committed contempt of court by failing to test on October 2nd? And
Guilty.
has anyone made any threats or promises to you to induce you to plead guilty to that?
No.
I accept your plea. You'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, I do.
Is it your own choice to plead guilty today?
Yes, it is.
So part of your bond conditions were that you needed to do drug tests with with the Lenawee County Drug Testing Agency. Is that right?
Yes.
And you also weren't supposed to be using any controlled substances. Is that right?
Yeah.
And did you test positive for cocaine on September 24 and September 30?
Yes.
And then did you fail to do your test on October 2nd and October 8th of 2024?
Yes.
I will accept the plea. It's been given understandably, voluntarily, and accurately. Ms. Ward's had full knowledge of the rights. She had competent counsel. Before the court passes sentence, Mr. Fry, is there anything you want to say on behalf of Ms. Ward?
Your Honor, so we had sentencing last week in this case, and Your Honor had given my client, I think, 10 days in jail, to because the court had expressed concerns, about her sobriety and wanted her to give her a chance to get clean, essentially in jail, where the court would know that, she couldn't be using. So I think she's scheduled to be released from that sentence on Friday. We would just ask that whatever the court does, it doesn't interfere with that, and she doesn't get any additional time than that. That time will have allowed her to get this out of her system. The court had granted her some incentives to comply with probation going forward with the 7411 status. So hopefully she'll take advantage of that when she's released. We know she's clean. She just needs to buckle down and comply with the terms of probation. Thank you.
Ms. Ward, is there anything you want to say on your own behalf before the court passes sentence?
No, sir.
All right, obviously, this is a contempt that is separate from the sentence on the underlying charge with court issued last Friday. I do think it's appropriate under the circumstances to give some additional consequence for those violations in addition to the sentence for the offense. Otherwise, the contempt, kind of becomes meaningless, and there needs to be consequences for our actions. So it's going to be the sentence of the court that Ms. Ward served 15 days in Lenawee County Jail. She does have credit for 7 days served at this point. So there will be a little additional time to serve beyond Friday. But that will be the sense of the court.
Thank you, Judge.
Ms. Ward, you can let the officer that's with you know that you are done with court for today.
Thank you, Your Honor.
Okay, Mr. Malero, are you there and off the phone with Mr. Santiago?
Yes, Judge, I am available. Sorry.
All right, so I'm sorry, which case was that, Ms. McClure, that you wanted to discuss off the record?
That was Patrick Stevens. Mr. Malaro and I have kind of had to change course in that matter. We were, I don't know if the court remembers, we were previously waiting to see his Allegan County Veterans Treatment Court options. And that kind of fell through within this last week. So we've changed course and are getting him screened for our Veterans Treatment Court. And that's already been set in motion. And just for the sake of time and the fact that I have to get over to Judge Anzalone, I didn't know if we could just adjourn that without him being present and while we await the answer on our Veterans Treatment Court.
Have any issue with that, Mr. Malero?
No, Your Honor, I was going to go see him today while I'm at the jail.
Okay. How far out did you want to look?
I don't know how fast the screening takes for Veterans Court, but we put that in motion yesterday. I talked to Ms. Rupley about it.
We plan on screening him at court next week, Judge. We have 3 to screen.
Okay, so screening the week of the 23rd. So we can do October 30th if that works.
That'd be fine, Judge.
That works.
Okay, Ms. McClure, can you do a stipulation in order on that one?
I can. And Ms. Teskey or Mr. Malaro, if you get any sort of response on that, just loop me into that so that I can discuss what my plea offer is going to look like with that.
Yep, we will after next Wednesday.
Thank you.
Yep.
For choosing.
All right, so I'm going to go ahead and log out then. And like I said, Mr. McCready can handle the last couple cases on the docket.
Okay, thank you.
Thank you.
Mr. Murphy, Mr. Ellison is here. Do you need a breakout session with him?
Judge Olsaver have Joseph.
Yes, Your Honor, I need to try to speak with him. I haven't been able to communicate with him at all since, his forensic stuff has occurred.
Mr. Ellison, if you are there, I need you to unmute your device. And then start your video if you can do that. Okay, thank you. So, Mr. Ellison, I'm going to put you in a breakout session with your attorney, Mr. Murphy, so that you can speak to him privately.
Okay.
Thank you, Your Honor.
What is that?
Trying to figure out, yeah.
Okay, Ms. Justice. Oh, okay, so Mr. Degerman is coming into the courtroom right now. This is file 23-21619-FH, 23-21620-FH, and 23-21621-FH. People versus Jenny Mae Justice. We are here today for pretrial conferences in those cases. We also have pending contempts to deal with as well. Mr. McCready, do you want to place your appearance on the record?
Dave McCready for the people.
And Mr. Dagger-Margosian?
Your Honor, Michael Dagger-Margosian for Ms. Justice.
Okay. Mr. Dagger-Margosian, where do we stand with Ms. Justice's cases today?
Well, Your Honor, obviously, these cases were scheduled for pretrial about a year ago at this point. And so now we find ourselves in this position. Obviously, Ms. Justice is in custody, not only on these cases, but on probation matter downstairs, as well as the contempts here as well. So on the underlying cases, and I was speaking with Mr. McClure this morning about these. On the underlying cases, we do have a resolution in place, but I do want to make sure that she is being held in on these so that she is getting credit. I just want to confirm that.
Yes, that is
I would assume
accurate. She had bonds on each of, there's a bench warrant in each file and a bond on each bench warrant. So she should be getting credit on all three files.
So, Your Honor, again, pursuant to my discussion with Ms. Justice, we are in a position to enter the plea as it was outlined on November 27th of 2023. And that plea will be to 2 counts of uttering and publishing and 1 count of forgery. Pursuant to that plea, the remainder of the charges in these 3 files would be dismissed. There'd be an agreement to dismiss the habituals and any supplementals, and there is an agreement, a sentencing agreement for no upfront MDOC. Ms. McClure indicated that she is not taking a position on sentencing, but that she would like, based on the failure to appear and potential contempt, she likely may be asking for some sort of jail at the time of sentencing. Again, that would be a sentencing issue that we would discuss at that time. And there would be restitution involved in this case that would be determined by probation.
Okay. Mr. McCready, is that a complete and accurate statement of the plea agreement?
I'm actually trying to find it right now. I mean, I'll take counsel's word for it, but I can't give independent confirmation on that right as of right now.
You say that was previously placed on the record, Mr. Dagger-Margosian?
I don't know if it was placed on record, but that is what Ms. McClure and I agreed to downstairs about a year ago while this gets spinning. And then, like I said, on November 27th of 2023 is when she and I agreed with this. I don't know if it was placed on record downstairs, but it's the reason why we waived these cases up here.
What is the file number that? Okay, so I have a.
It looks like the.
I'm sorry.
I was just going to say that it looks like the file in which you would be pleading to things would be 23-21620. That's got a couple of, well, let me correct that. So that would be, that file has one count of uttering and publishing, and it's got a forgery count, and then I guess we need the 23-2161. I'm sorry, 21621 file for the other uttering and publishing count.
So I don't see a plea form, but I do see a plea offer here. Plead to 1 uttering and publishing and 1 forgery. Restitution to be determined and must be paid in full at the time of plea, and no prison time. Is that consistent with what counsel indicated?
As far as the restitution, it would have been, but she's not able to make the restitution payment today, which would be the plea. So that would have to be taken up at the time of sentencing. As far as the plea to 1 count UMP, 1 count forgery, if that's the prosecutor's notes, then that's what we would go with.
All right, so Ms. McClure is in Judge Anselm's court in person right now. Why don't we pass this for a few minutes and maybe you could speak to her and make sure we're all on the right.
I'll talk right now.
Okay.
Thank you, Honor.
Okay, you're Mr. Getz?
Yes, Your Honor.
Mr. Malero, do you need a breakout session with Mr. Getz?
You heard me.
I did not.
How about now? Can you hear me now?
Yep, I can hear you now.
Yeah, if I could have a brief breakout.
Wait, one moment. Okay, Mr. Murphy, we have Mr. Ellison back from the breakout session now. Are you ready to proceed with him? Oh, you know what? We've lost our prosecutor, so it's going to be a minute or 2.
Okay. I'm here, Your Honor.
Oh, I'm sorry, I forgot Ms. Wagner was also here, so do have her request. Let me find that file.
Your Honor, there's a plea offer in this matter from Mr. Ellison to plead no contest to an attempted RNO. Now, I spoke with Mr. Ellison. There was an issue of competency, obviously, with the time and the treatment. Mr. Ellison has been deemed to be competent. Speaking with him, I believe he understands what the offer is. He does wish to accept the offer of a no contest plea to attempted RNO with a sentencing agreement to credit for time served.
Okay, so I am in possession of the certificate of competency to stand trial restored from the Kalamazoo Psychiatric Hospital dated October 1st, 2024. I think the right process is to do another competency hearing and find him competent. I take from what you have said, Mr. Murphy, that you at this point would, well, let me just ask, would you stipulate to entry of the certificate of restored competency as well as the attached report as evidence in the competency hearing.
Yes, Your Honor, I apologize for not properly following procedures on this. Yes, we've received those from the competency in regards to Mr. Ellison's competency. We would stipulate to the minutes of those, and we would, again, ask the court to proceed. And I guess with the hearing today to find him competent to proceed with the trial.
Okay, and Ms. Wagner, the people agree with or stipulate to entry of that report for the court's consideration?
Yes, Your Honor.
Is there any other evidence or argument to consider from the people?
No, Your Honor.
Is there any other evidence or argument to consider from the defense?
No, Your Honor. Again, I've spoken with him, and my conversation with him this morning is along the lines that he is competent.
Okay, so I have, as I indicated, received and reviewed that report dated October 1st, 2024, authored by Tara Brockman, MD, that has a thorough recitation of the evaluation that she performed and ultimately concluded that Mr. Ellison is presently competent to proceed with his trial. So I will find at this time that Ellison is competent to stand trial and we can proceed with the next stage in the process. So Mr. Murphy, you had indicated that, I'm sorry, did you indicate that he was going to enter a plea at this point?
Yes, Your Honor. There is an offer, and I was trying to find it. I could have it signed and sent over to the court, the plea offer agreement. But there was an offer from the people for Mr. Ellison to plead no contest to an attempted R&O, one count, with a sentencing agreement for credit for time served of the time he's been incarcerated. And he did wish. Sorry.
Mr. Murphy, do you want me to send that to you again real quick?
If the court needs a signed copy of it, I think my office can find it and we can have it sent over. I was just trying to find it right now. I don't think we need a new copy though. It's probably somewhere in my email.
Would that be like count 7 then?
Yeah.
Yes.
Okay.
Okay, I don't have an amended information in the file with a count 7. Has that been prepared?
Yes, I sent that on October 8th.
Okay,
Attempted R&O is still a felony though, correct, Amanda?
It's a felony for purposes of prior convictions, but it would technically be a 1-year misdemeanor.
1-year misdemeanor.
Oh, so I wouldn't be doing a PSI on him.
No, it'll go down to district court.
Okay.
okay. All right, Mr. Ellison, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yeah.
And you are Barry Deshawn Ellison?
Yeah.
Mr. Ellison, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 7, attempted assaulting, resisting, or obstructing a police officer?
There will be no contest, Your Honor. I'm sorry.
Yeah, I'm sorry. Is it your intention to plead no contest to that, sir?
Yeah.
Okay, you can put your hand down if you'd like. Are you satisfied with Mr. Murphy and the advice that he's given you?
Yeah.
Understand that the maximum possible penalty for that offense is up to 1 year in jail and or a $1,000 fine.
Yeah.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as it's been addressed on the record this morning. Is that correct, Ms. Wagner?
Yes, Your Honor.
Mr. Murphy?
Yes, Your Honor, that's correct.
Is that also your understanding, Mr. Ellison?
Yeah.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Ellison, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yeah.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
Oh, no.
Do you understand that you're giving those rights up?
Yeah.
How do you wish to plead to the charge that on or about November 28, 2023, in the city of Adrian, county of Lenawee, that you did commit the offense of attempted police officer assaulting, resisting, or obstructing?
Yeah. No contest.
Has anyone made any threats or promises to induce you to plead no contest to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record here today, or that it was not your own choice to enter the plea?
Yeah.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Ellison to plead no contest today?
No, Your Honor. Ms. Wagner, you're muted.
Okay, all right, thank you.
You're welcome. I'm sorry about that, Your Honor. Would you mind repeating the question? I was interrupted here too.
Are you aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Ellison to plead no contest?
No, I'm not, Your Honor. Thank you.
Mr. Ellison, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've talked about it today?
No.
Okay. Is it your own choice to plead no contest today?
Yes.
Okay. Mr. Murphy or Ms. Wagner, how are we establishing the factual basis?
Your Honor, I could place the facts on the record. I'm also asking I'm trying to send over to the court a copy of the police report. I don't know if one was provided. I apologize before that, but we would willing to stipulate to the minutes of that police report and use the facts of that. But again, I'm trying to see if we can get it over to the court right now. But if Ms. Wagner wants, if she wouldn't object, I could just place the facts on the record.
I don't object.
Okay, so let me just pull this up here real quick. So the facts of this case are as follows. This was established at the preliminary examination, and we would stipulate to the following: that Mr. Ellison was indeed in the city of Adrian, county of Lenawee, state of Michigan on November 28th of 2023. At that date and time, he was in the Adrian Public Library. He was asked to leave the Adrian Public Library by the manager or whoever, I don't know if it was assistant manager, whatever actually her title was. He was asked to leave. He was being trespassed. As such, there was police officers present, one of those being Sergeant Graff, I apologize if I mispronounced his name. Mr. Ellison did not respond, did not get up, did not leave. He basically went dead weight, and the Sergeant Groff, along with multiple other officers, had to carry Mr. Ellison out of the library there and into the police car and into custody. The entire time, Mr. Ellison went dead weight and did not comply with any orders that were being given. So we would again stipulate to the admittance of those facts for establishing the factual basis, and we believe that does establish an attempted R&O.
Okay, Ms. Wagner, are the people satisfied with the factual basis?
Yes, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D? Ms. Wagner?
Yes, Your Honor.
Mr. Murphy?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Ellison has had full knowledge of his rights. He's had competent counsel. The court hasn't made any agreement regarding the possibility of plea or sentence in this case with prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we've discussed it on the record here today. I will refer this matter to the district court probation office for a pre-sentence investigation. And we can set sentencing for November 14th, 8:15 a.m. I do need to get fingerprint information in the file before the court can conduct the sentencing, so I'm going to issue an order for fingerprints.
Would the court be willing to consider amending his bond at this point?
Ms. Wagner, you have any issue with amending the bond?
No, Your Honor. I would defer to the court's discretion.
I would ask the court to consider a PR bond in this matter. Mr. Ellison has been in custody for quite some time. The agreement from the prosecutor would include, credit for the time that he has served. I think Mr. Ellison, if he was to have gone to trial and been found guilty, ultimately its guidelines probably would have had him at what he's already served. Now, Mr. Ellison, I don't believe he has a history of failing to appear for court. There was a case that he had, a misdemeanor case a bit ago, that I believe I had him on in our file, and there was no failure to appear on that. Obviously, with this case, he was taken into custody, and he's been in custody this whole time. So I would ask the court to consider a PR bond because I don't believe there's a flight risk. This has come to a resolution. Mr. Ellison, he has been deemed competent, and he understands what's going on and what's proceeding, and the next step is purely the sentencing phase, which is the end of everything. And failing to appear for that would just mean to dragging everything out further and longer. So I would ask the court to consider a PR bond at this point.
All right, what I'm going to do is I'll issue a PR bond with the requirement that Mr. Ellison report to Darren Coast in Lenawee Pretrial Services. So Mr. Ellison, as soon as you're released, you need to come over to the courthouse and come up to the third floor and ask for Mr. Coast.
All right.
Again, I'm also going to issue an order for fingerprints, so you're going to have to get in touch with the City of Adrian Police Department to get your fingerprints done. You can do that Monday through Thursday at the Adrian Police Department at 7:30 a.m.
All right.
Okay. All right, I think we're all set then for this case. Again, Mr. Ellison, your sentencing is November 14th at 8:15.
All right.
Okay, so you can go ahead and log out.
Thank you, Mr. Ellison. Contact my office when you get a chance, okay?
Okay.
Thank you.
All right, Mr. Malero, are you ready to proceed with Mr. Getz?
I am, Your Honor. We'd also, after his arraignment, like to address bond on the matter.
Okay. This is file 24-22003-FH, People versus Joseph Douglas Getz. We're here today for an arraignment in this case, and we're proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Mr. McCready.
Dave McCready for the people.
Salvatore Malero on behalf of Joseph Getz.
Okay, Mr. Malero, does Mr. Getz wish to have the information read today?
At this time, Your Honor, we would waive reading of the information, waive any defects as a time and place of service. We would enter pleas of not guilty to counts 1, 2, and 3. Further would acknowledge receive the witness list and ask that a pretrial be set in this matter.
I will enter not guilty plea for Mr. Getz. We can set a pretrial for November 13th.
Thank you, Judge.
8:15 a.m. And Mr. Malero, you wanted to address bond.
I would, Judge. Your Honor, Mr. Getz is before you. He's a 37-year-old male. He has that I can find, no prior criminal history. These are very serious charges. They involve his estranged wife and her boyfriend. There was a pending misdemeanor case involving her, and then this matter is alleged to have occurred. That being said, he is a long-term resident of the county. He is employed. Judge, again, as I said, he has no prior criminal history. Judge, I believe the alcohol is a factor in this matter, in both the misdemeanor and this matter that's pending. I would ask the judge to consider modifying the bond in a form where Mr. Getz would be wearing a scram unit so that the court can monitor his whereabouts and any alcohol, and with the understanding that if he in any way breaks any bond conditions, he would be immediately remanded back to jail. That way allow him to further maintain employment while these matters are attempted to be resolved. He can maintain employment, which would be good for him in the future, his future. So we'd ask the court to consider modifying the bond to permit that. It would also further greatly help us in mounting a defense on his part. That's our request, Judge.
Mr. McCready.
Your Honor, I'm standing in on this one, so I'm trying to catch up on the facts. I do show that he, at least in terms of his CCH, does not show any previous convictions, but looking at the police report, the police were called to this home that, according to the police report, says that the defendant was not allowed to be there due to a bond condition. And when the police asked him, "Are you supposed to be here?" he stated no. And he assaulted the, I guess it's wife or ex-wife at that home. And she says that she is fearful of her safety if he's released. So I do think those considerations, at least the allegations, weigh against any modification of the bond. I guess there's a little bit more detail here that the complainant indicated there's an order stating that the defendant is not allowed at the residence due to a past domestic.
All right, that would be, I think, consistent with what Mr. Malero had indicated in terms of there being a previous or a pending domestic issue in bond conditions preventing Mr. Getz from being present at his ex-wife or former spouse's residence.
Dan, you want a donut?
So it looks like just looking through the probable cause affidavit that at least the allegation is that the prior domestic involved causing facial injuries to Ms. Getz. And this incident involves threatening and assaulting two people with a metal pipe or a jack handle. I think, to me, those are serious allegations. And when I couple that with the fact that there was already a pending domestic violence incident between Mr. Getz and his former spouse, that there's a real serious concern for safety. And I think that serious concern justifies the bond being set where it is at $25,000 cash or surety. And so I would decline the request to modify the bond at this time.
Thank you.
Thank you, Judge.
All right, Mr. Getz, you can let the officer with you know that you're done with court for today.
Thank you, Your Honor.
Thank you, Judge.
Great, thank you, Mr. Valero. Mr. Dager-Margosian, you ready to proceed with Ms. Justice?
Yes, sir.
Oh, and I'm sorry, Ms. McClure came into the court.
I am here and I'm drafting a very quick plea agreement
Okay,
placed on the record.
okay. Do you want to call for Mr. Valero? So we are back on the record in files 23-21619, 23-21620, and 23-21621-F-H People versus Jenny May Justice. We do have Ms. McClure present in the courtroom now, along with Mr. Dager-Margosian, and it's my understanding at this point that we have an agreement and everyone's on the same page.
Correct.
I believe so, Your Honor.
Okay. And so, Ms. McClure, what is that agreement then?
That in file 23-21620, she will plead to 1 count of uttering and publishing and 1 count of forgery. In 23-21621 FH, she will plead to 1 count of uttering and publishing. And then file 23-21619 will be dismissed. There will be restitution to be ordered at the time of sentencing. We're agreeing to no upfront Michigan Department of Corrections time, but we have no agreement on jail time. And is that it? I believe that's it.
Dismissal of the remaining counts.
And dismissal of the remaining counts.
No absconding.
And we won't charge an absconding as it relates to these, current charges that are pending.
Okay. Mr. Dagger, is that a complete and accurate statement, please?
Yes, Your Honor.
Ms. Justice, would you raise your right hand?
Yeah.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury? I'm sorry, I'm not able to hear you. Can you try speaking louder? Okay. And you are Jenny Mae Justice, correct?
Yes.
You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty in file 21620-FH to count 1, uttering and publishing?
Yes.
Do you understand the maximum possible penalty for that offense up to 14 years in prison?
Yes.
Is it also your intention to plead guilty today to count 4 in that file, forgery?
Yes.
And do you understand that the maximum possible penalty for that offense is up to 14 years in prison as well?
Yes.
Are you satisfied with Mr. Dagger and the advice that he's given you?
Yes.
Other than as we've discussed on the record today, neither the prosecutor, defendant, or anyone acting in the defendant's behalf has discussed. Correct.
That's correct.
Mr. Dagger,
Correct, Your Honor.
is that also your understanding, Ms. Justice?
I didn't hear what you said. I'm sorry.
Other than as we've discussed it on the record today, nobody has discussed a possible sentence with me.
No.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until your guilt is proven beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Ms. Justice, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
I'm sorry, I couldn't hear you.
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand you're giving those rights up?
Yes.
How do you wish to plead in file 23-21620-FH to the charge that on or about April 10, 2023 in the city of Adrian, County of Lenawee, that you did commit the offense of uttering and publishing?
Guilty.
And how do you wish to plead in that same file on the same date and location that you did commit the offense of count 4, forgery?
Guilty.
And in file 23-21621-FH, how you wish to plead to the charge that on or about June 22nd, 2023 in Madison Township, Lenawee County, Michigan, that you did commit the offense of uttering and publishing?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that those pleas were given as a result of threats or promises that were disclosed to court on the record this morning, or that it was not your own choice to enter those pleas?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Justice to plead guilty?
None, Your Honor.
No. Ms. Justice, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it here this morning?
No.
Is it your own choice to plead guilty?
Yes.
Or Dagger Magosi, do you want to do the factual basis?
Your Honor, if it's okay, I'll have Ms. McClure do it.
Yeah, I can.
Go ahead.
Ms. Justice, can you hear me okay?
Yes.
Okay, and I'm gonna start with, in April of 2023, did you go to a TLC branch on Main Street here in the city of Adrian, County of Lenawee?
Yes.
And at that time, did you write yourself a check, at least totaling $645, dated April 13th, 2023?
I honestly don't recall the dates or amounts of anything.
Did you remember taking a check to TLC Community Credit Union? And did you sign Wes Bonnie Jr.'s name to that check without his permission?
Yes.
And did you receive money for depositing or cashing that check?
I don't think that I did. They caught that and they didn't give me any money, I believe.
Would you agree that you were successful in cashing at least one check, and on the second two that you used that they did decline to give you money?
Yes.
Okay, so you at least received some monetary value for those checks?
Yes.
And at that time you knew that Wes Bonnie did not write that check to you?
Yes.
Okay. And then in June of 2023, do you recall going to TLC Community Credit Union in Madison Township, Lenawee County?
Yes, I think so.
And at that time, did you purport yourself to be an Emma Shaw on a check that you tried to cash?
Yes.
And was that again purported to have been written by a Wes Bonnie Jr.?
Yes.
And would you agree the date of that was, or the check was dated June 20th, 2023 in the amount of $525?
Yes.
And you knew that that check at that time was either forged, false, or counterfeit?
Yes.
People are satisfied with the factual basis on all three charges.
All right. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Dagger Magosi?
Yes.
All right, I will accept the pleas then. They have been given understandably, voluntarily, and accurately. Ms. Justice has had full knowledge of her rights. She's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them, other than as we discussed on the record this morning. I will refer this matter to the probation department for a pre-sentence investigation, and we can set sentencing for December 6th at 8:15 a.m.
What date did you say, Your Honor?
December 6th.
Okay.
Is Justice, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Your Honor.
Yeah.
Michael, has she been referred for drug court, recovery court?
No, not to my knowledge.
I'm not sure if she continues to struggle with addiction, but I know Miss Justice from the past, and that was kind of an issue for her. So you might want to toss that around.
Yeah, I guess we can get her screened, and at the time of sentencing, we can follow up on that.
Yeah, I mean, just to throw my 2 cents in case I'm not heard from, I do think there are some pending allegations of drug delivery. So I think that would preclude her from doing drug court.
Michael, I would like to screen
Up
that.
until, yeah, I guess up until she's ineligible.
Yeah, I don't know if the drug court screen does not happen with me, so.
Right. We'll we'll follow up on that.
Okay. Okay, so she also had contempt of courts in each file for the failure to appear. Did you want to address that today, Mr. Dagamagosi, or wait until the sentencing date?
Your Honor, I think at the time of sentencing, she'll be probably close to being maxed out, so I think we can probably just wait until then.
All right, so we'll address the contempts at the sentencing hearing. All right, anything else we need to address in these files today?
Nothing on behalf of the people.
No, Your Honor, thank you.
Okay, Ms. Justice, you can let the officer with you know that you're done with court for today.
Thank you.
Thank you. Mr. Murphy, do you need a breakout session with Mr. Blevins?
Yes, please, Your Honor.
One moment.
It's not in this, it used to be in the statute, then in the statute, but it used to be. As a policy, we should just.
Let's do Mr. Reds.
Can I just say what is and for the judge, please? Thank you. All right, bye.
Okay, you are Mr. Redis?
Yes, sir.
Okay, your attorney is with another client right now. As soon as he's available, I'll have you speak to him.
Okay, thank you.
Your Honor, I don't think I have anything left on my schedule. May I leave?
Yeah, sorry, you're all set, Mr. Malero.
All right, thanks. Have a good day, Judge.
Thank you, you too. Okay, Mr. Murphy, you ready to proceed with Mr. Blevins?
Yes, Your Honor.
This is file 24-21929-FH, People versus Nicholas Montgomery Blevins. We're here today for a pretrial conference in this case, and we're proceeding today by video conference. First, I have the attorneys place their appearance on the record, beginning with Ms. McClure.
Stevie McClure, behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Blevins.
And Mr. Murphy, where do we stand with Mr. Blevins' case today?
Your Honor, at this point, there is not an offer that Mr. Blevins wishes to accept from the people. I was thinking we may have to set it for trial. I wasn't sure what the court schedule was like for a one-day jury trial, one that would be occurring. I did want to ask if we could, I guess, set a jury trial, but also Mr. Blevins is currently serving a sentence that will be up on November 11th. So I didn't know if we could possibly have a pretrial shortly before that date. I know I guess that's kind of quick. But I didn't know if the court would be able to fit that in his schedule to see if things would change before he gets released on that sentence. If not, then obviously I would address that, maybe file a motion if I wanted to change his bond before then. Because again, I think we're going to ask for a one-day jury trial at this point.
Okay. Ms. McClure, anything to add from the people's side?
No, no position on that.
Okay, you agree one day is sufficient for a jury trial?
I would think so, yeah.
Ms. Clark, what is our first available one-day jury trial date?
We could do December 3rd as a backup to Jason Lindsay at 9 a.m.
Was that December 3rd?
Yes.
That would work for the defense.
Let me just check our calendar. I'm sorry. That should work for the people.
December 3rd for jury trial date. Let's do November 27th as a final pretrial date. And then Mr. Murphy, I could do another pretrial. We could do November 6th.
If we could, please, Your Honor, if it wouldn't be too much of a trouble.
Okay. All right, so we'll do a pretrial on November 6th, a final pretrial on November 27th, and a trial on December 3rd. Court will issue a scheduling order with all of those dates in.
Thank you, Your Honor.
All right, anything else we need to address today?
Nothing further from the defense, Your Honor. Thank you.
All right, Mr. Blevins, you can let the officer with you know that you're done with court for today.
All right.
Mr. Murphy, you need to speak to Mr. Redis.
If I could, please, Your Honor. Mr. Blevins, I'll be in contact with you, okay?
All right.
I'll come visit you.
Yep.
Judge, did Miss Wagner already log in and take care of Mr. Ellison?
Yes.
Okay.
I think all I have left is Mr. Redis, William Raymond, and a PPO on Aaron Lindeman.
Okay. All right. I have to go back to Judge Anzalone at 11, so I just want to let Dave know what we had left.
Okay.
Your Honor, what's the bond for Nicholas Blevins? Did you change that at all?
No, we did not do anything with his bond.
Okay, I just wanted to be sure, because I got him on probation as well, so I have to notate that
Okay.
if there's a change in bond.
All right. Miss Wagner's logging on for those last two.
Okay, thank you.
Yep.
Okay, 1 second. Ms. McClure had to log out, so Ms. Wagner is coming into the meeting right now.
You.
Okay, so this is file 24-21908-FH, People versus Timothy Lee Redis. Sorry. Bring in Ms. Rochelle, she is here as well. So People versus Timothy Lee Redis, we are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Wagner? Not appear. Ms. Wagner, can you hear me?
Can you hear me, Your Honor?
Yes, I can hear you now.
Okay, I can hear you now too. I'm sorry about that.
Okay, so this is People versus Timothy Redis. If you want to go ahead and put your appearance on the record.
Amanda Wagner for the People.
Matthew Murphy, appearing on behalf of Mr. Redis.
And Mr. Murphy, where do we stand with Mr. Redis's case today?
Your Honor, At this point, the people were offering for Mr. Reddish to plead as charged, I believe, to count 2 with no habitual, dismiss count 1. And I believe Mr. Reddish did want to, again, accept that offer to plead guilty to count 2 domestic violence, third offense with no habitual offender status and dismiss, with the count 1 being dismissed.
All right, Ms. Wagner, is that an accurate statement of the plea offer?
Yes, Your Honor, plea to count 2, dismiss count 1 with no habitual subs. That's correct.
Okay. Mr. Reddish, do you want to raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes,
And you are Timothy Lee Reddish, correct?
I am.
Mr. Reddish, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, domestic violence, third offense?
It is.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $5,000 fine?
I do.
Are you satisfied with Mr. Murphy and the advice he's given you?
I am.
Do you wish to explain or challenge the accuracy or the relevancy of any of the information? I'm sorry. Neither the prosecutor nor the defendant or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Wagner?
Yes, Your Honor, that's correct.
Mr. Murphy?
That's correct, Your Honor.
Is that also your understanding, Mr. Reddish?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Reddish, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
And do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights?
I do not.
And do you understand that you're giving those rights up?
I do.
How do you wish to plead to the charge that on or about July 23rd, 2024, in Ridgeway Township, Lenawee County, Michigan, that you did commit the offense of domestic violence, third offense?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you will be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
Mr. Murphy, do you want to cover the factual basis?
Well, Your Honor, if the people don't object.
No objection.
Okay. Mr. Reddish, can you hear me okay?
I can.
Okay, Mr. Reddish, were you indeed in Ridgeway Township, County of Lenawee, State of Michigan on July 23rd, 2024?
Yes.
Okay, and on that date, was it your home?
Yes.
What's the address of that home?
8903 Dibble Road, Ridgeway Township.
Okay. Now, at that date and time at that location, you would agree that you were there with, I'm going to use her initials in RR, that you resided with?
Yes,
She was a member of your household, correct?
yes,
Okay, and you would agree that at that date and time that you were engaging, you were being loud, aggressive manner, that you were being both verbal and your physical actions led her to have a reasonable belief that you may commit a battery against her. You would agree with that, correct?
yes,
Okay. Now you would agree that you have prior domestic violences, one from May 2013 in Monroe County, another one from April 2013 in Monroe County.
yes,
Your Honor, so I believe we established the factual basis.
Ms. Wagner, are the people satisfied with the factual basis?
Yes, Your Honor, the people are satisfied.
All right, has the court complied with MCR 6.302 B, C, and D, Ms. Wagner?
Yes, Your Honor.
Mr. Murphy?
It has, Your Honor. Thank you.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Redis has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department and for a pre-sentence investigation and set sentencing for December 6th at 8:15 a.m.
Thank you, Your Honor.
Redis, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
okay.
All right, anything else we need to address today then?
No, Your
No,
Honor.
Your Honor.
Okay, Mr. Redis, you can let the officer with you know that you're done with court for today.
Okay, thank you. Oh, sorry, one more thing. Me and Mr. Murphy had talked about, I'm on probation with Wayne County, but I'm supervised with Lenawee County. And so we were talking about if, once sentenced on this, would I be able to go to court over Zoom for the Wayne County probation violation, considering so I didn't have to go all the way out there?
I can't tell you how that's going to play out. That MDOC, the probation department, handles that. Some people I know, if they're living in a different county, can get their probation supervision transferred to the county they're living in, but that's going to be something you're going to have to take up with the Department of Corrections.
I'll try to get that figured out for you, Mr. Redis.
Okay.
Because if we can, obviously they'll be up to the court if they want to try to make you available to Zoom, if that's what they're trying to do. We'll get that clarified for you, okay? And I'll be in touch with you probably next week.
Okay, thank you.
Thank you, Your Honor.
Okay, so you're all set, Mr. Redis.
All right, see you later.
You have a good day, Mr. Redis.
You too.
All right, and then Mr. Murphy, I have not seen any sign of Mr. Raymond at any point today. He does have outstanding warrants. He apparently cut off his tether. And
Yes, Your Honor. I had spoken with him 2 weeks ago, discussing with him to turn himself in on the bench warrant that was currently out for cutting that tether. But I don't know where he is right now. I believe that he'll eventually come in and we'll be able to get him turned into the court. But obviously, right now there's a warrant, I believe, already out for him. So we're probably just ask that warrant be continued, I guess.
all right, so let me just call it real quick. So this is file 24-21807-FH, 24-21808-FH, and 24-21890-FH, People versus William Michael Raymond. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Wagner?
Amanda Wagner for the people.
Matthew Murphy, appearing on behalf of Mr. Raymond.
All right, and I did have a brief discussion off the record regarding the status of Mr. Raymond's cases. He does have pending or outstanding bench warrants in each file for the allegations that he tampered with his GPS device by either cutting it off or damaging the device, and he's not responding by phone. So at this point, it would be my intent to adjourn this without date and then proceed at at the time that Mr. Raymond turns himself in or is arrested on the bench warrant?
Yes, Your Honor. I spoke with Mr. Raymond a couple weeks ago. I do believe he is going to turn himself in. He's just trying to, I guess, make arrangements for that. So obviously, if I'm in touch with him and he's intending to do that, I'll call the court and we'll make sure everything's, straight. Also, he is aware that there's a warrant for him. Obviously, we're asking the warrant to continue. If he is not going to turn himself in voluntarily, I obviously can't control that. But I do hope that he is going to do it soon voluntarily. Again, he did reach my office twice. He reached out, so I do believe it's his intention to turn himself in. I just don't know what is holding him
Okay.
up. So I do apologize for that, Your Honor.
All right, so we'll just proceed whenever he turns himself in or alternatively is arrested on the warrant.
Thank you, Your Honor.
Okay, and
I think that's all that I had.
yeah, that is all I had for you. I still had two more for Ms. Underwood, but she is not here. I don't know. I guess Ms. Wagner, I've got another case that was supposed to have started at 10:30, so when and if we catch up with Ms. Underwood, we'll give you or somebody in the prosecutor's office a call and figure out what we're gonna do with Wade and oh, I'm sorry,
Sounds good, Your Honor.
just Mr. Lindeman's the only one left. Okay.
It will be available whenever you're ready.
Okay, thank you.
Thank you.
No, you're talking. Okay.
Breaking news.
We're good. Judge already checked in with us.
Oh, okay.
Yep. Morning.
Morning.
All right, fair enough.